Yes.
Right Honourable Speaker, the chair of the committee intends to dissuade the House that there is no dissenting report. There is a dissenting report that was submitted to the chair of the committee, and rightfully so, he should have probably made us aware that it is there and almost signed by half of the committee.
The chair will bring that. Just be patient, it will come. The chair, after reading his report, will call for the dissenting what? Views.
Right Honourable Speaker, just a few seconds ago, I have been handed over the minority report. I wish to lay the minority report. And there was no intention whatsoever, but the fact is, if there is a second one, you present. Right Honourable Speaker,
and honourable members, stop smuggling minority reports in the House. The reports must be received, we upload them, and we handle them.
Thank you.
Nobody will be denied to present a minority report, but just bring them in a formal way.
Right Honourable Speaker, I wish to present the report of the Consolidated Committees of Defence and Internal Affairs and Legal and Parliamentary Affairs. This bill addresses the policy principles, and briefly, it streamlines the composition of the defence forces and establishes healthcare service for its members. The bill creates a medical board. It defines service offences. It defines...
A report is being presented.
Let him finish his report.
Yes.
Hansard, capture all the reports. Capture all the reports. Yes, Honourable Wilson, go ahead.
Thank you, Right Honourable Speaker.
Are you Wilson? What is it?
Right Honourable Speaker, the procedural point I'm raising, I sit in the Committee of Defence and Internal Affairs. Right Honourable Speaker, you gave the committee the task to look at the bill and come up with the report. And when we were writing the report on Monday, before we reached half of our report, the chairman told honorable members that they are going to Entebbe to attend the caucus, and they will come back. We shall continue with the report. Right Honourable Speaker, the chairman did not come back, and we did not continue with writing our report. Is it procedural right, Honourable Speaker? I don't know where the report came from. Let the chairman clarify to members, because we did not complete writing our report on that day. Right, Honourable Speaker, we need to be very serious. And it's so bad to keep on smuggling what is not agreeable by honourable members. Where did you get this report from? Yet the committee did not complete. Right, Honourable Speaker, let us put the record right. In fact, we did not complete working on this report. And we did not process it.
Honourable, where did you get your dissenting views for you to write a minority report? Because the minority report is, say it. The minority report is signed by you. Where did you get the dissenting views? Chair, continue.
Thank you. Right Honourable Speaker. Right Honourable Speaker, the bill streamlines composition of defence forces. It establishes the health care service of members. It creates a medical board. It defines service offences, military courts, and reserve force, while restructuring the courts martial per Article 129, 1D of the Constitution. The proposed qualifications of the chairperson of the courts martial to ensure independence and allow for appeals. This bill specifies circumstances under which civilians may be subject to military law and outlines the offences tried under courts-martial. Additionally, Right Honourable Speaker, this bill establishes a military courts department, a disciplinary unit for enforcing discipline within the military court system. It prescribes defence forces exclusive arms and ammunition. It manages veterans' affairs and repeals the Uganda Veterans Assistance Board Act Cap 221 and related matters. This bill, Right Honourable Speaker and Honourable colleagues, addresses the defects in the existing law. The UPDF Act, the Uganda People's Defence Forces Amendment Bill 2025 amends the UPDF Act Cap 330. This act, enacted in 2005, regulates the Uganda People's Defence Forces as provided under Article 2010 of the Constitution, replacing the Armed Forces Pensions Act Cap 295 and Uganda People's Defences Act Cap 307. Notably, the defense sector has undergone significant transformation since 2005, driven by emerging threats and opportunities, many of which the Act does not adequately address. The Act did not include health care for the officers and militants, management of military veterans, pensions management, or service medals conferred by defense forces. Since 2005, the UPDF administrative structure has changed significantly, with Special Forces Command and Reserve Force elevated to independent services. The Uganda People's Defence Forces Amendment Bill 2025 reflects this evolution. Additionally, Right Honourable Speaker, the bill seeks to align the Act with the Supreme Court decision in the Constitutional Appeal number 2 of 2021, which is Attorney General versus Honourable Michael Kabaziguruka. What are the objects of this bill? It seeks to amend the UPDF Act Cap 330 to streamline the composition of the organs and structures of the defence forces. It establishes the health care service for members of the defence forces. It establishes a medical board. It provides for the definition of service offences, the court-martial, military court, and reserve force. It provides for the restructuring and establishment of the courts-martial in the defence forces in accordance with Article 129(1) of the Constitution and prescribe for their jurisdiction. This bill provides for the membership and qualifications of the chairperson and the courts-martial and the independence of the courts-martial. It provides for appeals from the courts-martial. It provides for the exceptional circumstances under which civilians may be subject to military law and prescribe the offences for which civilians may be tried by the courts-martial. Right Honourable Speaker, this bill provides for the establishment of the military courts department within the defence forces. It also further provides for the establishment of a disciplinary unit within the defence forces, which shall be responsible for the discipline of the members of the military courts department. Also prescribe the arms and ammunition which are a monopoly of the defence forces and classified stores of the defence forces. It also provides for the management of the veterans' affairs. It also repeals the Uganda Veterans Assistance Board, Cap 221, and for related matters. Right Honourable Speaker, for the record, we consulted as is demanded by the processing of the bill. We met and held discussions, constructive ones, with stakeholders like the Ministry of Defence and Veterans Affairs. We also met the Attorney General. We held discussion with the Office of the Director of Public Prosecutions. While processing this bill, Right Honourable Speaker and Honourable colleagues, we also entertained private legal partners. In this case, Counsel Julia Mukama. We also entertained and audience to Kampala Reduced veterans of the UPDF, who gave us enriching reveal concerns about compliance with constitutional principles, judicial independence, defense and administration of military justice. 611, the trial of civilians under military law. Clause 29 and Clause 30 of the bill address individuals under military law and the court-martialing of civilians. Clause 29 revises Section 119 of the Principal Act to clarify who falls under military law. The amended Section 117 stipulates that all defense forces members are governed by military law. Meanwhile, Clause 30 introduces a new Section 117A detailing additional individuals who may be governed by military law. This section specifies persons not part of the defense forces that may be subject to military law under exceptional circumstances. From the above, the provisions indicate two categories of individuals under military law: a member of defense forces and a civilian involved in activities outlined in Section 117A. The committee notes that amendments in clauses 29 and 30 of the bill seek to bring the Principal Act into accordance with court's ruling in the Constitutional Appeal number 2 of 2021. This Attorney General versus Michael Kabaziguruka, which included several observations, recommendations, and others regarding individuals governed by military law. Following consultations with various stakeholders on the bill, the committee encountered diverse opinions on the Supreme Court's orders, effects, and recommendations regarding civilians under military law. Some witnesses objected to trying civilians in military courts, arguing that Supreme Court's interpretation prohibits such actions. In contrast, other committee members and stakeholders, including the learned Attorney General and the Minister of Defense, contend that the Supreme Court did not fully ban civilian trials in military courts, suggesting instead that such trials could occur under exceptional circumstances. The committee has examined this matter and concludes that the trial of civilians by military courts should occur only in exceptional circumstances, ensuring that a fair trial is guaranteed. The committee acknowledges that military laws apply to officers and personnel within the defense forces, but they also address elements of national security. As a result, civilians can engage in actions that usually impact national security, which are typically reserved for those under military law. The reasoning for establishing offenses in the Updf Act that hold civilian criminally liable is to safeguard national security. The committee reviewed the exceptional circumstances outlined in the bill and determined that certain aspects require revision to align with the legality principle. Specifically, the committee identifies that paragraph D, which allows the trial of civilians in military courts for aiding and abetting individuals subject to military law in committing serious crimes such as murder, aggravated robbery, intent to murder, kidnapping, treason, misprision of treason, or cattle rustling need adjustment, since it fails to specify the elements of these offenses. This omission compromises the legality principle defined in Article 28(12) of the Constitution. Furthermore, the committee observes that while civilians are penalized for aiding and abetting these crimes, primary offenders face no penalties. The committee supports the proposal for trying civilians in exceptional circumstances, provided that amendments to the Updf Act ensure a fair trial. This requires changes to the military court structure to ensure that those presiding over these trials have legal training and appointed through a transparent process, a function independently of their superiors' influence. The committee, therefore, recommends that clauses 29 and 30 form part of the bill, albeit with amendments as proposed. 6.12, restructuring of courts martial in alignment with the Constitution, particularly Article 129(1)(d). Right Honourable Speaker and Honourable colleagues, the proposed restructuring of the military courts as outlined in the bill aims to align the unit court-martial, division court-martial, and the general court-martial with the Constitution under Article 129(1)(d) of the Constitution. It introduces provisions on the qualifications, appointments, tenure, and jurisdiction for the service offences. Additionally, the bill establishes military courts department to oversee justice administration within the defense forces. However, the committee noted that the roles and functions of the military courts department are vague, leaving gaps in oversight and accountability intended to oversee military courts. The structure risks undermining judicial independence. The military courts department includes the head general court martial as chair, along with military prosecutors, defense counsel, and chairpersons of the military courts. This overlap of judicial and prosecutorial roles is seen as a violation of natural justice principles. It threatens the right to a fair hearing by compromising impartiality of the courts. Additionally, a key concern arises from the provision allowing the Chief of Defense Forces, in consultation with the High Command, to assign an acting rank to the head of the General Court Martial when the accused has a higher rank. While intended to maintain order, this mechanism may introduce bureaucratic delays and allow manipulation of the justice process. For instance, the Chief of Defense Forces could delay rank assignment impending the prosecution of senior officers. The temporary rank, with its associated privileges, may also incentivize judicial officers to prolong proceedings to retain benefits, hence compromising timely and impartial justice. The committee therefore recommends that the proposals contained in the bill regarding composition and structure of the military courts should be supported, albeit with amendment to engender fair trial provisions as proposed in the committee's amendments. Appointment of the presiding officers and members of the courts martial. Right Honourable Speaker, the committee notes that Supreme Court emphasized that military courts, despite being specialized, exercise judicial power and must therefore uphold the same safeguards of independence and impartiality guaranteed under Article 129 of the Constitution. While the
Is it 129 or 128?
I beg your pardon. Guaranteed under Article 128 of the Constitution. While the bill amends qualifications by requiring legal training for the presiding officers, committee expressed significant concern over the appointment process. Currently, all members are appointed by the High Command from a list it generates in consultation with Judicial Service Commission. This system grants the High Command broad powers to appoint members for specific trials, raising serious doubts about the members' independence and vulnerability to external influence. The idea of consulting Judicial Service Commission does not explicitly define the role of Judicial Service Commission in the process of appointment. The committee argues that the Judicial Service Commission should be given a stronger role to vet presiding officers who wield judicial power. The committee contends that military courts must be governed by judicial oath and legal principles. We therefore recommend that persons presiding over military courts should be appointed by the Commander-in-Chief on the recommendations of Judicial Service Commission from the list generated by the High Command. Tenure of service. The bill allows a 3-year renewable tenure for chairpersons of court-martial, but is silent on the terms of other members. The committee noted that secure tenure is vital for judicial independence safeguarding judicial officers from arbitrary removal or political pressure. A 3-year term is inadequate, and unclear removal grounds for members create insecurity, risking impartiality. Citing Justice Asaf Ruhinda-Ntenje and another versus Attorney General, Constitutional Petition number 33 of 2016, which declared fixed term contracts for 5 years for all members and the defining grounds for removal to protect judicial independence. The committee recommends that a term of all members be increased from 3 years to 5 years and is eligible for reappointment. 2, that the term should apply to all members of the courts martial and not limited to the chairperson as proposed in the bill. Appeals from decisions of courts martial. The bill permits unit court martial to the division courts martial to the general courts martial, and from the general court martial to the court of appeal, with the Supreme Court as the final appellate court. The Attorney General explained that since the High Court lacks appellate jurisdiction over capital offences, appeals for such cases must lay directly to the Court of Appeal. The committee agreed with this reasoning, but raised concerns about the practicability of requiring officers and soldiers in remote areas to travel to Kampala for the General Court Martial appeals. This could be costly and could hinder access to justice. Additionally, the right to appeal where the aggrieved party is dissatisfied with the unit court martial decision has only right to appeals, while a division court martial decision can be appealed to the Supreme Court where viewed as unfair. The bill restricts appeals on legal matters, making decisions of the chairperson of the unit and the division court martial final. The committee deems this untenable as it prevents parties from challenging potentially erroneous legal decisions, risking miscarriages of justice. The bill's clauses on the appeal and enforcement of sentences, particularly regarding the death penalty, were also problematic. The phrase of notice of intention to appeal differs from a formal notice of appeal, creating ambiguity and risk that death sentences could be executed before appeals are determined, violating Article 22(1) of the Constitution. This article guarantees that no person shall be deprived of life except after a fair trial and confirmation by the highest appellate court. We therefore recommend, Right Honourable Speaker and Honourable colleagues, we recommend the following. 1, that appeals from the unit court martials should lay with the division court martial. 2, the decisions of a unit or division court martial on matters of law and facts should be open to challenge. That appeals from decisions of the general court martial should lay with the Court of Appeal as proposed in the bill. 4, proposed section 2272 should be deleted and section 2273 be aligned with the provisions of Article 221 of the Constitution. Structural reorganization of defense forces. The committee acknowledges vital role of Uganda People's Defense Forces that has played in upholding national security and preserving and defending sovereignty and territorial integrity of Uganda. In light of the evolving security threats and expanding military responsibilities, there is a critical need to realign the UPDF structure. Structural reform is based on Uganda's legal framework, specifically Article 2010 of the Constitution that empowers Parliament to make laws regulating Uganda People's Defense Forces, in particular, provide for the organs and structures of UPDF Section 2 of the UPDF Act, Cap 330, provide for the mandate of Parliament to make laws, prescribe any services beside the land and air forces. At present, these two branches are central to the military operations of the UPDF, which also receives assistance from the reserve force during emergencies. A significant advancement has been the emergence of Special Forces Command, a specialized allied unit tasked with carrying out specialized missions or operations at the moment's notice, very important persons, protection, and reconnaissance. While it is not legally provided for as a distinct service, the SFC holds a crucial position in linking conventional and special operations, collaborating closely with both land forces and air forces. The committee notes that the bill restructures the UPDF by creating new services such as the SFC and the reserve force to improve operational capacity and responsiveness. New organs such as the Joint Military Command and Service Command and staff committees are being established to enhance coordination, policy formulation, and strategic oversight. This reorganization also includes renaming and defining roles in the command structure for clarity, for efficiency, and alignment with the current security needs. The committee therefore recommends that the proposal to restructure the UPDF to formally integrate specialized units such as the SFC as a distinct service branch should be supported to institutionalize specialized capabilities, enhance inter-service coordination, and ensure compliance with the legal and oversight requirements. On veterans affairs and pension reforms, the committee notes that the bill proposes transferring administrative and management of pension and gratuity from the Ministry of Public Service to the Ministry of Defense and Veterans Affairs, aiming to enhance service delivery and more effectively to meet the needs of the military personnel. A key aspect of this reform is the establishment of the Pensions Appeals Board to provide a formal mechanism for addressing grievances and disputes related to pension matters. Additionally, the repeal of the Uganda Veterans Assistance Board Act Cap 221 signifies a shift towards a more integrated and updated legal framework. These reforms also introduce comprehensive provisions for retirement benefits, gratuity, and pensions, including entitlements related to death in service and disability, ensuring improved welfare and dignity for the serving personnel and the veterans alike. The Kampala reduction in force UPDF veterans informed the committee that although they voluntarily enlisted in the National Resistance Army struggle, which ultimately resulted in a change of government, they continued to serve in the NRA UPDF until their discharge, which occurred without a proper and formal dismissal. The committee notes that the UPDF has transformed since the 1990s, following significant military downsizing after achieving stability post-internal conflict. This began demobilization efforts, and restructuring of the UPDF alongside pension reforms for veterans. The reduction in force affected thousands of personnel, especially older veterans and non-combatants, aimed at enhancing security and lowering public spending. However, systemic issues in the pension system emerged as many veterans faced unclear entitlements, delays, and bureaucratic hurdles in obtaining their benefits. Scholars such as Obore in 2006 highlight that while legislation aimed to guarantee pension rights, many veterans remain unrecognized due to inadequate documentation all unclear classifications, e.g., informal service or voluntarism, not recognized as pensionable. Thus, the committee believes that while the bill will strengthen the pension and gratuity administration for the UPDF veterans, actual realization of the rights remains uneven for the demobilized veterans. Additionally, the bill currently excludes individuals or militants who retired before its enactment, which lacks a commencement date. Its provisions have no retrospective effect and do not address retired officers and militants. Right, Honorable Speaker and Honorable colleagues, we therefore recommend, 1, that decentralization of the pension authority to the Ministry of Defense and Veteran Affairs, as proposed in the bill, should be adopted to enhance efficiency, transparency, and responsiveness in addressing pension-related issues for military personnel and veterans alike. Welfare and health services. The committee observes that the bill proposes establishing a health care service.
Madam Speaker, I'm rising on point of order. Earlier you had ruled that this front bench be reserved. As it is now, the several members appear to be part of my team, but when I invite them to support me, they shy away. Is it in order that they sit here is it in order for them to continue defying the ruling that you made, that this front city be reserved for the members? Is it in order?
Honorable Wilson, continue.
Thank you. Right Honorable Speaker, I am now addressing committee's concerns and observations on welfare and health services. The committee observes that the bill proposes establishing a health care service for the Defense Forces personnel, creating a dedicated health care service for the military personnel,
listen to the
introduces
report.
Right Honorable Speaker, creating a dedicated health care service for the military personnel introduces extensive health care system, including routine medical care for the dependents of the officers and militants, rehabilitation services, and access to specialized treatments abroad when necessary. Additionally, a Defense Forces Medical Board has been established to manage medical evacuations, to manage medical evaluations, conduct disability assessments, and approve treatment for officers and militants. These reforms are designed to ensure that all military personnel receive timely, effective, and specialized health care during their service and after their service. The committee opines that a dedicated health care service for the defense personnel, separate from civilian, addresses a unique nature of military service requiring specialized, timely, and continuous medical support tailored to risks faced by the defense forces. Military personnel often need rapid access to trauma care, rehabilitation for service-related injuries, and treatment for psychological conditions from combat or deployment. The Defense Forces Medical Board will ensure medical evaluations, disability assessments, and treatment decisions aligned with the military standards and readiness, which civilians' health care may not adequately address. The Joint Committee therefore recommends that 1. Establishment and operationalization of a dedicated health care service for the defense personnel, as opposed in the bill, be fully supported and adequately resourced to ensure the delivery of specialized, timely, mission-specific medical care, addressing the unique medical and psychological and rehabilitative needs of the military personnel. Monopoly and security classifications. The bill introduces measures to strengthen monopoly and security classification concerning crucial military assets of the UPDF. It specifically outlines which arms and ammunition are solely under the control of defense forces, guaranteeing that these materials remain inaccessible to unauthorized parties. Additionally, the identification and safeguarding of classified equipment and materials will now be regarded as sensitive to national security and will be strictly regulated according to military protocols. These reforms, Right Honorable Speaker and Honorable colleagues, aim to bolster national security, prevent unauthorized access, and uphold operational integrity by ensuring that only designated military officials oversee and protect these assets. However, the committee observes that the classification and categorization of materials under the exclusive control of the defense forces, particularly military uniforms, can have significant implications for civilian wear. When clothing that closely resembles military colors, patterns, or designs are classified as military property, civilians wearing similar attire or clothing may face restrictions or even legal consequences. This is specifically in context where the resemblance is coincidental or fashion-based rather than intended to personate military personnel. For instance, in the bill under Clause 82, Schedule 7B, several uniforms for ceremonial wear, including ordinary black shoes, kaunda suits in the coffee brown, blue, and khaki, have been categorized as exclusive wear for the defense forces. Yet, these are very colors of clothing and black shoes are seen as ordinary wear by the public. Be that as it may, the committee asserts that civilians wearing military-style attire and berets, even without official insignia, significantly risks military identity, public trust, and operational scrutiny. Such apparel can confuse the public, undermine military distinctiveness, and grant an earned authority to those not following military codes. In operational or emergency situations, the difficulty in distinguishing trained service members from similarly attired civilians may compromise coordination and increase risks, potentially damaging the armed forces' professional image. Recommendations. We therefore recommend that Schedule 7B should be amended to include a requirement for marking military stores with the logos and insignia of the UPDF, thereby distinguishing them from civilian items. 2, that a provision should be inserted to restrict the wearing of camouflage military-style uniforms and berets by individuals who are not part of the military. Conclusion, Right Honorable Speaker and Honorable colleagues. We therefore recommend that the bill be considered for the second reading, subject to the proposed amendments attached hereto and any other modifications the House may propose and approve. Right Honorable Speaker and Honorable colleagues, I beg to report.
Thank you. Thank you so much. Thank you. As you're informed that we have a minority report from Junior, Okot Moses Junior. Please present your report. Go to areas of dissent.
I'm not speaking.
Abib, you extend. You're disturbing Junior.
The Right Honorable Speaker and members, I move to present the minority report. But prior to the presentation, I intend to make an opening statement. In arriving at this report, we, the members of the joint committees of Defense and Parliamentary Legal Affairs, did in a higgledy-piggledy manner, haphazardly, reached a position that would qualify the report that I am reading to be the majority report. And to justify the same, we had about 14 members signing this report out of the total number of members of these two committees.
How many members signed the majority report? Let's get a difference between majority and minority.
Right Honorable Speaker, the majority report has been signed by a total number of 26 members.
The joint, yes, then the joint 14 decide. Okay.
While I finish making my submission prior to reading to this report, is that I want to urge the members that if reason, persuasion, logic, and science has never taken the day in this House, let it take today, because this is a very critical part of the bill that I decided out of the opposition to remain in this House so that I present logic, science, reason, and law to the House.
Just finish and wait.
There's an order.
Thank you very much, Right Honorable Speaker. I rise on a point of order. This House is constituted of distinguished ladies and gentlemen representing this country, and we've been handling business since the beginning of this term. Is it in order for my friend to say we are illogical, that we have never applied logic in this House, and it is only him who is illogical in this House? When we represent our different constituencies, is in order to demean and insult us as members of this House?
Thank you. The members of this House reason with the reason and with the logic. And these are honorable members of Parliament. So whenever there is a debate here, it is done with logic and reason. So we cannot have a House belittled to that level. So Junior, withdraw your statement. Junior.
Rightfully so, Right Honorable Speaker, I withdraw.
Honorable members, allow me to chair the House. Junior has withdrawn the statement and will be expunged from the Hansard. Because the members that we have here are members of logic and reason, and they are honorable members of Parliament. Yes, Junior.
Right
You
Honorable
go and
Speaker.
look for them.
Right Honorable Speaker.
Junior, continue.
In Right Honorable Speaker, if the House may please, I will read.
Read your report.
Right Honorable Speaker and colleagues, this is the statement of the minority members of the Joint Committee of Legal and Parliamentary Affairs, Committee of Defense and Internal Affairs on the decision of the majority in respect of Uganda People's Defense Force Amendment Bill 2025, herein referred as the UPDF Amendment Bill. This statement is made pursuant to Rules 214 and 215 of the Rules of Procedure of Parliament of Uganda. The UPDF Amendment Bill 2025 was read for the first time on Tuesday, 13th of May 2025. And in accordance with the Rules 134 and 200, referred Joint Committee of Parliamentary Legal Affairs and that of Defense Scrutiny. The object of the bill is to amend the Uganda People's Defence Force Act, Cap 330, to majorly give effect to the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazaruka, among others. Pardon, members, I am born, raised, nurtured of a Luo descent, and there are certain syntaxes that may not appear.
Go ahead, Honorable Kabazaruka.
The decision of the Supreme Court in the Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabaziruka, is well detailed and uploaded. I am going straight to read the point of dissent to allow members probably. Point of dissent is on 330. And this is the substance of our submission. Our dissent from the majority is guided by Article 9, by the 1995 Constitution of the Republic of Uganda and the Supreme Court judgment in Attorney General versus Michael Kabaziruka, Constitutional Appeal number 2 of 2021, arising from Constitutional Petition number 45 of 2016. As a locus classicus case, in addition to other authorities, the point of dissent are: 1, contravention of the Constitution; 2, illegality in military trial; 3, offending the doctrine of separation of power; 4, lack of public participation; 5, unconstitutional expansion of the military court's jurisdiction; 6, constitutional limitation on Parliament's power; 7, lack of independence and impartiality of the court-martial; 8, non-compliance with the judicial advisory order of the Supreme Court ruling. Members and Right Honourable Speaker, on issues of contravention of the Constitution, Article 92 of the Constitution provides a restriction on retrospective legislation. Parliament shall not, if I may, Parliament shall not pass any law to alter the decision or judgment of any court between parties to a decision or judgment. The above provides a bar on legislative powers of Parliament in enacting any law that has effect of overturning or altering the decision or the judgment of court. Clause 30 of the bill proposes to introduce a new section, that is section 117A in the UPDF Act, to provide for other persons who are subject to military law. The provision requires that a person other than a member of the defense force shall be subject to military law under the following exceptional circumstances: where a person voluntarily accompanies any unit or element of the UPDF of the defense force which is in active service in any place; B, where while serving in defense force under the engagement by which he or she has agreed to be subject to military law; C, where the person is in unlawful possession of arms, ammunition, equipment, ordinarily being a monopoly of the defense force, prescribed in Schedule 7A of this Act, or classified as stores prescribed in Schedule 7B to this Act, commits an offense under any written law. D, where the person aids or abets a person subject to military law in the commission or conspires with a person subject to military law to commit the offenses. The offenses below: 1, murder; 2, aggravated robbery; 3, kidnap with intent to murder; treason, misprision of treason, or cattle rustling. E, where the person without authority is found in possession of or sells or wears a uniform of the defense forces, or where the person is found in unlawful possession of arms, ammunition, or equipment ordinarily belonging to the monopoly of the defense force prescribed in Schedule B of this Act. G, where a person is serving in position of an officer or a militant of any force raised and maintained outside Uganda and accompanied by the officer of the defense force. The above clause is an attempt to reenact Section 117 of the Updf Act, which was struck down by the Supreme Court for offending Article 28(1), 44C, 128(1) of the Constitution. Such is inimical to the rule of law, good governance, which is a cornerstone of democratic dispersion, and that of other civilized nations and communities across the globe. It also constitutes an egregious attack on judicial independence, thereby contradicting Article 28(2) and 3 of the Constitution, which provides that no person or authority shall interfere with the courts or judicial officers in the exercise of judicial functions, and that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure effectiveness of the court. See Article 20 and 3. This action amounts of the Supreme Court is criminal, a path that must be leaded by Parliament. Honorable Speaker, Docus Classicus case.
Do you have to add a dissent, Parliament? Must you add dissent? Nobody doubts that we are dissent.
Avoided by our Parliament. Mr. Oblige.
Expand the word dissent.
In the Locus Classicus case of Liang in 1967, there is Parliament a retrospective law affecting the trial of individual accused of attempted coup. Council struck down the law on account that it sought to alter the course of a particular decision and effectively overturn the jurisdiction. The Indian Supreme Court in Indira Nehru Gandhi versus Raja Nara in 1975 SC 2299, after election was invalidated by the High Court constitutional amendment that was passed to validate the election. The Supreme Court struck the amendment, holding that the Parliament cannot enact legislation that overturns specific judicial decisions. Any legislation passed with the object of annulling the effect of a judicial decision has been held to be an encroachment on the judicial powers, and it is unconstitutional. Your Honor, coming down, there were other authorities that, Right Honorable Speaker, rather, and colleagues, there were other authorities that were cited year after to persuade the House. I urge members to peruse while I go to deal with the dissent. The second area of dissent is illegality in military trials. Your Honor, Speaker, the question of in military trial is ably canvassed by the Supreme Court in the case of Mike Kabaziruka in the above case. Owindolo CJ, in his lead judgment at 180 and to 180, this to Right Honourable Speaker. There are also other vital reasons militating against trials of persons to military law for all offences. These courts has previously held that there are certain offences that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to the specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on court-martial jurisdiction to try such offences. For instance, since terrorism can only be tried by the High Court, which is an ordinarily civil court.
Honorable Court Junior.
Yes, Your Honor.
Honorable Justice, Chief Justice Owejidolo had this to say. Open court, and then you close the court. Somebody will imagine
Most obliged.
that it continues up to the end.
Most obliged.
Close the
Right
court
Honourable
first.
Speaker. And if I may proceed from where I'd stopped, Right Honourable Speaker.
For clarity, say what Chief Justice said, open court, close it, then you bring your statement.
Right Honourable Speaker, the CJ, Justice Owejidolo, in his lead judgment at page 180 to 185, had this to say. Open court. There are also other vital reasons militating against persons subject to military law for all offences. This court has previously has held that there are certain offences that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for cause by conferring court jurisdiction to an offence. For instance, since it can only be by High Court, an ordinary or civil court would be contradictory to try it military court as well. And also it would be self-defeating for an offense similar to terrorism to be created under the UPDF Act and then the persons are tried under it, close quote. I find this holding by Mulenga by Justice of the Supreme Court, Justice Mulenga, still position of the law, and where jurisdiction is expressly excluded, or where the DPP's consent is a prerequisite, the court-martial are not competent to handle that matter, so excluded, irrespective of the provision to the contrary. Under the impugned section 117 and 117I, G and H of the UPDF Act, it amounts to duplication to grant jurisdiction to the court-martial over it when, owing to the gravity of these offences, Parliament conferred jurisdiction over them to ordinary courts. The other issue for consideration is the danger possessed by concurrent jurisdiction, where the military courts could try a case that is also before an ordinary court. This would necessitate the establishment of a mechanism between the court-martial and the DPP to manage the cases, beyond mere provisions in the UPDF Act, and the jurisdiction of the court-martial does not take away that of the civil courts. Concurrent trials in both military and ordinary courts for civil offenses would also be prejudicial to an accused for a simple reason that it could lead to double jeopardy, as each court could potentially come up with a guilty verdict. Additionally, as already noted, the General Court Martial and other military courts are subordinate courts. See, in the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Justice Mulenga's finding, where he held that the General Court Martial is subordinate but not lower than the Court Martial. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placed in or belonging to a lower rank or class or position, or subject to another authority or control. Assigning an ordinary meaning to the word subordinate, all court martials as subordinate courts created under Article 129 1D can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than that of the High Court is contradictory and has the potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them the jurisdiction to handle capital cases, then it would need to do so in line with the Constitution. I will return to this later in advisory opinion to explore the options that could be undertaken by Parliament to achieve this effect constitutionally. With this finding, the hearing by all court martials of offenses within the jurisdiction of the court martial is under 28, 128, 129D. Close quote. The general rule alone have jurisdiction civilians. The was able to any rational justification justify between the maintained dispute or maintain of borders and civilians court generally. However, having held as above, the Chief Justice made the following orders. A. The provisions of 179 2 and now 171 and 2 of the UPDF Act.
71 or 177 1 and 2.
179 1 and then 1 and 2 and then 177 1 and 2 of the UPDF Act. Read together with 197 2 and now 197 2. Which grants subordinate military courts jurisdiction over capital offenses, contravenes Article 121D and 126 of the Constitution. And they are unconstitutional. Provisions of Section 1 and G, now 1 and G is unconstitutional to the extent that it permits trial court martials of civilians who allegedly debated of offenses or criminal offenses in which a person subject to military law is a principal. Right Honorable Speaker, the minority observes, I'll jump D, the minority observes that the Supreme Court's decision had the following effects. The trial of civilians by court is only permissible in exceptional circumstances and only after state has concretely demonstrated to court by verifiable facts and by objective and serious reasons, need and justification for a recourse to a military court. 2, the minority observed that military courts can only have jurisdiction in relation to specific class category of specific offenses. For specialized courts such as Anti-Corruption Court under the Anti-Corruption Act, International Crimes Division under the Anti-Terrorism Act. 4, military courts cannot have jurisdiction of offenses which require the consent of the DPP. The consent of the DPP. 5, cannot commit or be tried for service offenses, even when abet or aid the commission of offenses. 6, when and military personnel are committed a crime, service offense, be tried in 7, government cannot duplicate offenses prescribed by acts of introduced in the UPDF. Colleagues, members of parliament, the of the provisions of Article 28 petition to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, to appear competent, independent, fair, impartial, or a tribunal. The decision of the Supreme Court, trial of persons with offense.
Kale, behavior ya UPDF amendment bill bila bili mwetano. Mubala bya batulidde mu olukwe obiteeke olanya wano musajja omulala ne jimerwanga ya bantu bana. Jeno Museveni bayiseemu n'abakolera minority report ne bagata ku kiri report kye bayise UPDF amendment bino katubasabire betemere mukubogo kubasiba tutujja kubasiba batubalinde bekolera amateeka ge bagenda okusi